There we go. always a little hitch. Okay, so Byron Batres, thank you for attending. I was born in Guatemala, and I came to the United States when I was 5 years old. So my full name is Byron Ricardo Batres de Bon. Feel free to say that, just say it with a Spanish flair. Like I mentioned earlier, I am a certified financial planner. And so for 20 years, I help people avoid probate. It's one thing to kind of know it in theory, it's another thing to go through it. And so I actually was there we go. I was an executor. So in 2012, I became an executor of my wife's grandmother's estate. And the one thing that's really interesting about that responsibility is you're not just some heartless banker that is going to decide, what to do, who sells, what to sell. You actually are the person someone chose to fulfill their wishes. If there was no will, then you're the person that's stepping up to be the person in charge and actually, close the affairs or clean up the mess on someone's life. And so there's always a person involved. And so Mary Ellen, this is my wife's grandmother, fabulous woman, had a business, owned real estate, and had, just like everybody, assets when she passed away that she wanted to distribute. What makes probate challenging is oftentimes the relationships that are involved. And so this is our family at Mary Ellen's house during one of the many Christmases we spent there. And my wife was a little bit of a surrogate daughter, if you will, to Mary Ellen. A little bit of a kind of family dynamic. Her father was estranged and a lot of issues going on. And this is where probate can get tricky. So Carrie's father, there the cowboy, really was upset that he wasn't chosen. And he presented a challenge at every step of the way. The reason I'm telling you this is that we have specifically gone through probate and know exactly all the issues that arise. And in my particular case, the challenge that he presented was very normal, which is to say he was simply upset that he wasn't the executor, not a real legal challenge. This is actually the challenge that he presented to the court. Relatively easy to fight off, but produces a lot of stress. So our goal today is to walk you through all of the probate process, what can happen, some of the things that you can do, when you might need an attorney, when it might make sense to do things on your own, and really show you how all of it works. I actually have a saying that says, probate is easy, really the family is hard. And so I'm actually kind of curious for the audience here, how many of you who are potentially dealing with probate expect challenges or objections from your family? We'll get a bit, a few seconds here. And that'll give us an indication of maybe what to talk about and what not to talk about. So it looks like the majority of you are doing the poll. And all right, I think that's almost everybody here. So I'll end the poll in one more second. So, all right, we'll end the poll. And then, so right now, with the people involved, almost none of you think there'll be an objection and one person will. So congratulations, you're gonna have, for those who are sure no objections will happen, you'll probably have an easy time with probate. It's really just the forms, the family is sometimes the challenge, like I said. All right, so now let's launch in. So what is probate? Probate is the court supervised process of transferring assets after someone's passed away. So all the assets, debts, and things that the person owns really just has to be finalized. The assets that go through probate are any assets owned individually by the individual that don't automatically transfer to somebody else. So think of kind of IRAs with a beneficiary, life insurance, that kind of thing, that transfers automatically without a court order, but anything in someone's individual name does not. And so, anything individually requires a court order. So probate means to prove. You have to prove the will valid if there is one. Obviously, the will nominates the executor and designates who is going to inherit. If there is no will, you have to prove who the heirs are. That is, who is going to inherit. And you definitely want this process to be formal, because imagine for a second, I show up to your bank with a fake will that says, give me all your money. It makes sense that there would be some process for a judge to kind of oversee that. So again, you really have to make things valid, and the proof is essentially the order from the courts. So you definitely need that proof. How long does probate take? There's really no one answer to this. So I thought it might make sense to go through the probate process. And so probate is, lengthy. It can be time consuming. And so when you think about the different stages of probate, it makes sense to think about the timing. So you're going to first petition the court for the letters of administration or letters of testamentary, and that usually takes about a month, right? So once you have your paperwork done and you send it to court, you will have a hearing in most cases, and that time period from petition submitted to the hearing is about a month. Then there is the time period that you have to notify people. So that's you have to notify their heirs, who's going to inherit. You have to notify creditors. You're going to have to notify any interested party. And that can range from a few months to sometimes over a year. And the reason it can be that long, it's not like it takes that long to send them a notice, is that there's a concept called the creditor claim period. So a creditor has X amount of months to make a claim to the estate if there is one. And so that's really the creditor claim period. That varies from 3 months typically to almost 2 years in some cases. So think about that. So really the range is about 3 to 12 months. Typically, you're going to have to do an inventory, which is telling the court what's in the estate. What's in the estate is obviously the assets and the things that, the personal belongings. And so most courts require that the estate produce an inventory roughly around 3 months after you've been appointed. Now, paying the expenses, creditors, taxes, that kind of stuff, that really varies depending on the estate. As you can imagine, if you have no creditors, if you have no bills and no taxes are due, there's nothing to do here, so you would move on to the next section. If there are creditors, if there are things to kind of go through, this could take long, but typically it might take 3 to 6 months on average in our experience. And then, of course, there is the distribution phase. This is where you are now for sure know the assets, for sure know who the creditors are, because you've now passed the creditor claim period. And now you're ready to report to the court to say, this is what I've done, this is what I have left, and this is who I'm going to give it to. And you present that to the court. The court would then do an order for distribution, and then you can distribute the assets. And the final stage is closing the estate. That really takes less than a month, because once you have the order from the court to distribute the assets, you distribute the assets, you will get a receipt and release from every heir / beneficiary, and then you just tell the court that you're done. And that really takes not a lot of time. All right. So the next, stuck. There you go. So really the main emphasis here is that what can make the estate take a long time is the creditor claim period. So the creditor claim period and the complexity of the assets really is going to be the majority of the reasons it takes forever and complicate estates. In most cases, when siblings get along, relatively simple estates, it's actually really easy. It doesn't take a lot of time. In our experience, roughly 4 to 6 months is what we have seen estates really closing. So it's not that hard. So who needs to be notified? This is one of the questions that we get asked a lot. I don't want to tell my brother, I don't want to tell this person, but there are statutory requirements as to who is going to be notified. And the people that get notified are the next of kin, called heirs at law. These are the people that will inherit or would inherit if there is no will. So if there is no will, they're called an heir at law, and this is the next of kin. By law, even if there's a will and they're disinherited, they have to be notified, because that gives them an opportunity to potentially challenge the will or say, hey, I am the long lost brother, the long lost son that no one knew about. The other people that get notified is anybody who's named in the will, if there is one. That includes beneficiaries, the executor or successor executor. So anybody named in the will be notified. Other people that have to be notified are known creditors. So if you know a creditor exists, like a mortgage, credit card company, that kind of thing, you will have to notify them, as well as other interested parties. What's an interested party? Literally anybody who says, I'm an interested party. Probate is very public, it's in court. Anybody can file basically a notice of interested party. That just means that they will be notified. It's pretty rare that that happens. And then, of course, if there are creditors that you don't know of, if there are heirs that you don't know of, how do you contact them? Well, you do a public notice. That's a legal ad in the paper. Very, very different than the obituary. It's a legal ad in the paper that says, XYZ estate is going to be opened, and any creditors or unknown heirs have so much time to present themselves. The next question that we get asked is, who inherits? People who inherit are if there's a will, they are named in the will. So if the will is valid, it is proven valid in court, only the beneficiaries named in the will can inherit. If there is no will, then the intestate succession, fancy word of saying no will, the state law determines who inherits. The state does not get any assets. Only the next of kin can inherit. And typically the order of priority is surviving spouse, children, parents, siblings, aunts and uncles. Whoops. If there are no family immediately, then you literally go to the closest next of kin. So essentially it goes, if there's a surviving spouse and children, only they inherit. If there is no spouse and no children, then parents get involved. If no parents, then siblings, and so on. So you really have to go down the order of priority. Once you get to a order of priority, you stop. So if there are children, you don't then go further down. What assets go through probate? We touched on this a little bit. So very simply, any asset owned individually by the person who passed away will go through probate. And so that includes things like bank accounts in their single name, things like a vehicle, real estate, personal property. Now the stuff in the house is typically presumed to be owned via the deed, right? So whoever inherits the house typically will inherit the stuff in the house unless specified if there's a will. If there is no will, then the stuff in the house is just divided equally, depending on the order of priority. Anything that is like an income asset, think of income producing, where it might be like a royalty, or obviously sometimes like a famous singer or actor dies, anything that they would have earned income on. Any income earned by the deceased is an asset of the estate to be inherited. Now, very often the safety deposit box, there might be stuff in there. And so that's something that is part of the estate. Very often that's where the will is found. And so how do you present the will if it's in the safety deposit box? There's always a petition to open up the safety deposit box and present any findings there, especially if there's a will. So you can actually open up the safety deposit box with a limited order from court. Common examples of things that don't go through probate. That would be anything that's jointly held. And mind you, there are two types of joint assets. jointly held with rights of survivor. And then there is, I forgot to end the poll. All right, so then jointly held with rights of survivor. And then there's assets that are jointly held, what's called tenants in common. And this is an important distinction because jointly held assets with rights of survivor, once somebody dies, the surviving person instantly and immediately owns the rest of the assets. So that would not be a probate asset. However, if it's tenants in common, so tenants in common simply means that two people or more own one asset, but they own separately, right? So each share of that asset is considered individually owned. Those would be a probate asset. That's the next one. Okay, there we go. Anything that is owned via a beneficiary designation does not go through probate. Now, a beneficiary designation needs to be valid. So that means that a real live person is chosen as the beneficiary. If the person who's chosen as a beneficiary has already passed away and there is no contingent beneficiary, then that asset becomes a probate asset of the person who owned the asset, not a probate asset of the person who would have inherited if they were alive. So the owner of the IRA who dies and has a predeceased beneficiary, the owner of the IRA, that asset goes into their estate. Any asset that has payable on death. So payable on death are types of designations you can put on a bank account, investment account. I die, then I want this asset to transfer. Very, very similar to a beneficiary, except obviously beneficiaries are IRA and life insurance. Payable on death, transfer on death are specifically for bank accounts. Another type of transfer that is similar to this is buy-sell agreements. If there's any business that has ownership where the owners have a buy-sell agreement, upon my death, the other owner buys the assets, that also would bypass probate, at least the transfer of those shares. And then any asset owned by a trust. By definition, a trust, the trust owns the asset, therefore the deceased does not own the asset. So then those assets do not go through probate, they bypass probate. There's a whole other seminar we could do on how to avoid probate. We won't confuse this now, but you can avoid probate. If you have questions about that, please contact us in the future. We can walk you through how to avoid probate. Now, the question that we often get is, do you need an attorney? And there is certainly times where that is absolutely necessary, sometimes even required by law, and other times not. So let's kind of go through some common examples. So currently 5 states in the US require an attorney by law. Those are Texas, Florida, I'll forget a couple of them, Texas, Florida, Missouri, there is Iowa, there's one more, Mississippi. And so those states require an attorney in most circumstances, not all. Oftentimes we have found that states may not require an attorney, but the judge does, which is a weird situation because, you know, it shouldn't happen, but it does. And so Cook County is a good example, Chicago area. Most of our people who have tried to do probate have not done that successfully on their own without an attorney. Now, you might consider, we would often recommend to use an attorney if the estate has complicated assets. So you can get through probate, but what if Aunt Peggy stole money? What if there is an unwrongful death lawsuit that has to happen? Or maybe there's a business that needs to be liquidated and transferred that has complicated issues. Well, you may be able to do probate without an attorney. However, transferring those assets, getting the lawsuit going, obviously would require an attorney. If the estate is insolvent, if there are more debts than assets, you really should consider legal advice because there's a very, very, very specific order of who gets paid when there is not enough assets. And we often recommend that you consider using an attorney in those situations. If there's a contest, now mind you, my petition was contested by my wife's father, and I did not use an attorney. In that particular case, it was actually really easy to kind of, you know, not have the contest matter. But sometimes, you know, it is important to have an attorney. If you're going to contest what is a valid contest. Typically, somebody has to be proven incompetent as the administrator, like you're a convicted felon, maybe you've had bankruptcy, or whoever's you're trying to contest. That's a way to get rid of the administrator. Or if the will is in fact not valid, you would have to prove that invalid, and that is hard to do. Hence, an attorney would be very likely required. And so that's when we recommend the attorneys, and we actually have attorneys we can refer you to if you need. We would be the first people to tell you if you need an attorney or not. And so feel free to, when you have questions, we'll definitely go over your case and tell you exactly what we think is needed. We do have an official attorney plan on our website as well. All right, now let's go over how much things cost. And so probate is very variable because the situations change, the state dynamics change, and all the circumstances are different. But let's kind of go through some general averages and scenarios. So typical legal fees. So if you were to use an attorney, they can range from $3,000 on the lower end to $10,000 on the higher end for simple cases. And by simple, I mean nobody's contesting, brother or sister get along, inheriting everything, easy peasy. Attorneys often charge by the hour, and that can range and increase the cost. And some states allow the attorneys to charge up to 5% of the value of the estate. So again, all these variables can lead to different costs. The other thing that you'll need to worry about or pay for is court fees. That can be literally $1 if you qualify for some of the simple small estate procedures, and up to $1,200. I think New York State has the highest court fees, but typically they're about $300 to $500, somewhere around there is the court fees. And then the public notice, that is the legal ad that you have to do in the paper. That will range from $50 to $1,500. The most expensive would be the New York Times and LA Times. You would never need to do those. You can always find more local, less expensive papers. Let's see, now there's a poll. Let's see if I can do that poll. Yeah, hold on, relaunch. I don't know if you expect to, no, right now I only have one poll. All right, well, so sorry about that. Let's, yeah, we'll just close that poll. Okay, we had another poll, but it's not working. So let's go back to the slide. All right, so let's take an example. A lot of you are coming from California. Let's take an example of what a typical probate fee in California would look like. And so most attorneys start with a retainer. Think of that as a down payment. In California, very, very typical to have somewhere between $5,000 to $8,000, sometimes $10,000 retainers. That's just the down payment. There is a statutory fee in California, which is essentially what attorneys are allowed to charge. And for $1 million house, just for easy math here, plus in California, average medium value of a house is about $800,000. So again, just easy math here. The statutory fee would be about $23,000. You would pay an initial filing fee of $435, the ending filing when you close the estate of $435, and then a filing of the will. And then here we're choosing a paper, LA Times, $750. So your total cost for probate in Los Angeles is about $24,670, or 2.47% of the estate. That is crazy expensive. And when you think about that, the only difference between one estate and another is the number on the form. It really is crazy. And mind you, when you are the person in charge, odds are you're the person that's already paid for the funeral. You're the person that has already paid the mortgage, some bills. I remember when I was, when the attorney said, my retainer is going to be X, I was like, listen, buddy, I'm tapped out. I'll write you the check. It's just going to bounce. And so oftentimes when you're in that position, you really are at your wit's end because you can't afford to even start the process with an attorney because of their retainers. This is a real example of a California statutory fee calculator. So this is part of the petition. Obviously, I scrubbed any identifying information. The asset was the house, $480,000. I think this was LA. No, this was San Diego. And then they sold the house. So based on the sale of the house, a little bit more value from the starting point. And so they had about $537,000. And the statutory fee in California is 4% for the first 100, 3% for the next 100, and then 2% from 200 to 800. So if there was an attorney, this is one of our customers, the attorney would have charged $13,700. What is missing in this calculation? Anybody? Debts. If there was a mortgage, which there was, and the mortgage was consuming most of the assets, which often happens, the attorney fee is based off of the top value, not the net value. And in this case, I think they had maybe about $80,000 worth of total equity. To charge $13,000 on $80,000 inheritance, well, I think that's wrong. And so that's some of the things that, a lot of estates have to deal with. So how does EZ-Probate work? How are we different? Number one, we're online. We are instant. You go to our website, you answer an easy questionnaire, it takes about 20 minutes. We will produce a sample of the petition for probate so you can see. We are available via our chat. We're available via email for questions. A lot of people also can schedule a free consultation or ongoing questions after customers have started. Once you're ready to move forward, you pay, you get all your documents down to be able to download, and then you're able to file essentially at your pace. You don't have to wait for an attorney. You don't have to wait for, or pay an exorbitant retainer fee. We also are easy to contact. This is an example of our Calendly, which is how people can schedule a free consultation. You will notice that we take calls all the way through 8:30 p.m. We're on the East Coast, so that's a little bit early on the West Coast, but really trying to make ourselves available for all our customers. And we also take weekend appointments. Our pricing, we charge flat fees regardless of the asset size. So for our do-it-yourself pricing, it's $600 flat fee. Whether you have a $20 million estate or a $100,000 estate, it's going to be $600. What we produce is all the forms with instructions so that you can do this on your own. You will get video instructions, you'll have step-by-step instructions. So most of our customers are able to do this on their own. This is typically recommended for relatively easy cases and people who are, I would say, tech savvy, who can follow online instructions and the such. We also offer a concierge level, where our concierge is essentially, we provide more help. We will send the documents for you to electronically sign. We will e-file, we will arrange the public notice. So then all you have to do is appear in court. And then our attorney plan is a flat fee of $5,000, and then you literally do nothing. The attorney will appear on your behalf. We do the documents, the attorney reviews, files, and is available for any actual legal questions. More importantly, all of our plans can be started with as little as $120. We do have payment plans for all of them. And so we try to make this very accessible and affordable for those who need it. So going back to that kind of $1 million example, if you were to use our most popular plan, which is the concierge, flat fee of $1,250, same filing fee, same closing filing fee, same filing of the will, and then we would have known which local paper to use instead of the LA Times and save you a little money as well. With EZ-Probate, we make it very affordable, and so anybody can afford, to do probate. We have the world's, I would actually say the universe's greatest online probate team. We're also the only online probate team, so not a big bar to hurdle. And also we have licensed attorneys in many states. Currently, we offer our attorney plan in California, New York, Florida, Texas, and Illinois. We also have a couple other states, little ones that we have some good relationships with, but any of those states, we can very quickly offer an attorney plan if you need it. because of my experience, because of our availability, we really our goal is to make probate as easy as possible, which is the paperwork part. Because like I said earlier, probate is easy, the family can be hard. And we're going to be with you no matter what, step by step until probate is over. We don't leave you at any stage hanging. And that concludes the presentation. I apologize for I had some more polls out there for whatever reason didn't work. So now I'll have Rebecca go through some of the questions. Oh, yes, and I should introduce her as well. Sorry. So Rebecca is our Chief Marketing Officer. We got introduced to each other through a startup competition called Mass Challenge. And she has been working with us since late last year. And yeah, she is awesome. And without further ado, Rebecca, what are some of the questions that our participants have?
Thanks, Byron. Thanks everybody for joining us today. We appreciate it. Just to let you know, if you weren't able to make all of it, we will be providing it by recording and also be offering this every 2 weeks. So if you know someone else that needs to know this information, we already have the information available on the site. So the first question, Byron, today is from Gravette asking, I'm an only child and no objecting people. I just need direction, what I need to do to become the executor to settle my mom's affair.
Sure. So essentially, to become the executor, you do have to petition the court to prove the will valid. That's just submitting the paperwork to the court, notifying all the people that need to be notified, and then the court often will have a hearing. Some states, there is no hearing, it's informal unless somebody objects. And so once the court has all the paperwork, then you become the executor. So I would recommend that you go to our website, EZ-Probate.com. I think, Rebecca, you can send the link to everybody and just start the questionnaire totally free, and we'll give you all the forms that you need. And mind you, these forms are most of the time free and publicly available. And so you can find the forms yourself. Sometimes it'll be challenging to actually understand how to fill them out, but that's where we come in. So yes, petition the court, and then you'll be able to get started. Depending on the state, you may or may not be able to get these forms easily on your own.
Okay, Byron, the next question is from Penny. I live in Florida. I'm an only son. I have copy of pour over will stating trust as beneficiary. I'm listed as sole beneficiary in trust. I have original copy of trust. There's not a question, but I'm assuming the question is, what do I need to do?
Right. So very common to only have a copy of the will. This could be because no one knows where the original is. Often the attorney has it and won't give it up unless you hire them. So most of the time when there's only a copy of the will, there's just an extra petition to submit a photocopy of the will. And so it would be essentially the same process as if you had the original will, a few extra forms saying, I can't find the original will, I'm submitting the photocopy of the will. And that really starts the same process as normal. So you would petition the court, likely have a hearing, and then you would become the executor. Note in Florida, Florida is one of the few states that have what's called a homestead status. So if the property in question is the homestead of the individual, there's actually an easier process. So definitely reach out to us. We can explain that a little bit more thoroughly, because Florida does have a unique process if it's the homestead.
The next question, Byron, is how can I start an administrative real property claim?
Sure, I think that means that how do you become the administrator to then claim the property for whoever's supposed to inherit? Again, same kind of process. You would petition the court to become the administrator of the estate. Simply means there's no will. You would tell the court who is the next of kin, who's supposed to inherit. Then you would get the authority to become the administrator and then essentially transfer assets and such. I do see that people are raising hands. So keep your hand raised, both figuratively, and then I think we'll be able to actually have you ask the question live. So being the administrator is almost like being the executor. It's the same power, except there's just no will. And so once you are the executor or the administrator, and you're able to transfer the assets, you would then do a quitclaim deed to whoever is supposed to inherit, and then the asset becomes that person's.
The next question I apologize in advance if I mispronounce your name, Kajala. It's guns are in the name of the deceased and need to be transferred to single heir. Do I, as the court appointed administrator here, have to have a gun license to fill out those forms?
Great question. The answer is really complicated because this is partially probate related, partially gun state specific law. In our experience, only New York has a very, very specific procedure for probate to transfer guns. So let's start with the concept of personal property, right? Because a gun is typically, well, I guess guns can be registered. I apologize in advance, I'm not a gun owner, so I know a little bit about guns only through the state of New York probate because we've done that a couple of times. But typically personal property, unless there's a deed registration like a car, I think guns are registered as I talk out loud in many states. And so you would then have the court order authorizing you to transfer personal property. You would then transfer the gun through whatever agency that is. And then oftentimes you do have to tell the court that you've done that, especially because gun ownership is regulated very differently state by state. I live in Vermont. I can tell you from what I know in Vermont, there is no gun registration. I've heard that you can just give somebody the gun. But again, that's a little bit more state specific, but the probate process, you would treat the gun like any other asset. And then you would simply just transfer it through the normal probate process.
The next question is from Cindy. Can we request an invoice from our lawyer to determine the cost?
I think I understand the question as, can you try to predetermine the cost of an attorney? Most attorneys do not tell you a fixed cost. And sometimes that seems unfair and sometimes that's fair because how do they know how much work or complications it'll be? But yes, you will be invoiced by the attorney. Most states have what's called statutory maximum fees, but there's a lot of variables. So as I understand the question, I wouldn't say that you'll get a real legit one price before you start.
And then Lynn is asking if the bank account has the daughter on it jointly and IRS and retirement all have beneficiaries, would anything else need to be done? Does family file public notice or is obit enough in this case? And she's in Ohio.
Yeah, so great question. So this is the type of situation where nothing needs to be done. And I actually point out that probate is never required, right? So in this situation, assets have transferred or will transfer without a court order. Jointly held assets of a bank account, IRA beneficiaries, assuming there's nothing else in the asset pool, you don't need court. You can do the obituary, that's more like a, kind of like a nice thing to do. You don't have to do it. In that situation, nothing would need to be done in court. Now, the opposite sometimes happens is, imagine there's like $500 in the bank account, but $10,000 in credit card debt. Sometimes people are like, I don't want to do this. You don't have to do it. You could essentially just lay with those assets fallow, as they say. So there's no requirement to do probate, but probate is required to transfer assets. Hopefully that makes sense, right? So if there are assets to transfer and you want those assets, then you would require probate.
The next question is from Maria. How do you apply for an ancillary estate if the original probate was approved in the state of New York in 1997 and the land is located in the state of Florida? She had a follow-up saying, we're selling the Florida land, but the title company requires a probate from the state of Florida.
So ancillary probate means a secondary probate. That just simply means that probate is started. Actually, there's something we didn't talk about. Where do you start probate? Probate is needed where the deceased was a primary residence. So that would be the initial probate, or is also needed wherever they have real property. And by real property, I mean real estate, land, any type of deed related asset. So you would probate, in this case, they've already probated in Florida, dealt with whatever assets are in Florida, but there's land or real estate in New York, you would then, or vice versa. They started probate in New York, now they need probate in Florida. So the petition for Florida would simply say, they point to the petition in New York, it's already been done, it's already has been done, and it's actually an easier process because you don't have to go through the whole proving the will valid if there is one, proving who the heirs are if there are, or whoever inherits, because that's already been done. So ancillary probate is just simply the second probate, and you bypass all of the initial, petition and such.
The next question is from Debbie. She says she's an only child and has the original will and lives in the house, but she wants to live in the house after probate. I'm assuming the question here is, how does she ensure that that happens?
Sure. I'm sorry, I was making sure that we were looking for the attendee who rose their hand. I think that is can you repeat the question?
Yep. Yes, this is the one who raised her hand. She's an only child. She has the original will, lives in the house, wants to live in the house after probate. So I'm assuming the question there is, how does she
make
sure that that happens?
So number one, you have to become the deed owner. So you can't just walk up to the recorder of deeds and say, I'm the only child. You have to petition the court to have the authority to transfer the property. So you would do the same thing. You would petition the court, if you have a will, to accept the will, then the will is valid, you have the letters of authority, then you do a quitclaim deed, right? Transferring the property from the deceased to yourself. Please note that the only way you can do a legit deed transfer is to have the authority. So if I were to show up to your house with well, not your house, but to the recorder of deeds in your county with a quitclaim deed saying, give me the house, they will say, no, we can't be filed. So you need the letters of authority attached with the quitclaim deed to have a legit deed transfer.
So the next question is, my mom has a deed in her name and her partner's name. Her partner is deceased 13 years with no heirs or will. She has a will with my brother and me as the heirs, and I am the executor. Her other assets are payable at death or beneficiary. Our state is Louisiana. There's no survivor rights or common law. Can I probate myself, or would I need an attorney?
Yeah, so we have done Louisiana probates. Louisiana is one of those states that's a little unique. So the history of law, if you will, is most of the United States is what I call a child of England, right? So there's common law, we're colonies of England, that kind of thing. But Louisiana obviously is more French. So there's parishes, not counties. And so there's definitely some quirks in Louisiana, but yes, you can petition the court to do this on your own. Louisiana does have very, very, very unique inheritance rules. So I would recommend that we maybe talk offline or contact us specifically to go over those. But there is no requirement to use an attorney in Louisiana. And again, I say that with caution because sometimes the judge requires it. So it kind of depends.
The next question is from Steve. Can real estate be sold prior to probate in the name of the estate's owner?
Can real estate, well, I guess if I understand the question, if the person is alive, yes. If the person is dead, you need probate to officially transfer title. So let me ask the question, let me rephrase the question. Can you engage a realtor before you have the authority from court? So imagine I'm going to petition the court tomorrow or in a month. Yeah, I'll petition the court tomorrow. It takes about a month to get the letters of authority. Can we engage a realtor to put the house for sale so that by the time I have letters of authority, we have a purchase and sale agreement and we can close the house? The answer is yes. However, you do obviously have to disclose to the realtor, to the potential buyer, that the sale would be contingent upon you having the authority to sell the house. So as long as you disclose that probate is going to happen, that you are likely to get the letters, yes, you can sign a purchase and sale agreement. You can do all that. And then the escrow would just be waiting once you have the letters of authority, because once you have the letters of authority, that's when you can sign the official transfer, the actual closing statements, all that stuff. And then the estate gets the money, not the heirs yet. The estate of would get the money.
So, question from Eric. Is there a time limit from the date of death to petition the court, obtain letter of testamentary, etc.?
Yeah, there is no time limit. There's no and a will does not expire. So it is often advisable to do it as fast as possible. Because remember, unless the estate is open and somebody has letters of authority, nobody's in charge. So the risk of waiting too long is What if there's a fire in the house? What if a tree falls on the house? Nobody owns the house, therefore, nobody can fix the house. The insurance technically is not valid, or at least the insurance can only be paid to the deceased, hence the estate. So again, no time limit, but certainly some risk if you wait too long. The oldest case that we've done, we did a case where somebody died in 1937. And it was like great-grandchild was the one who came to us. Why? Because a tree fell on the house, and the insurance company was like, you guys don't own the house. We got to pay it to great-grandmother. So we had to probate, all the way down. So yes, you don't have to, there's no time limit, but there are risks to waiting.
So the next question is from Lynn. Is a transfer on death document for automobile that is leased or only for those totally owned?
Transfer on death is not common in automobiles because again, the DMV is the entity that would govern who owns it. And so I have not seen that very common, frankly. I'm not saying it's not possible. If you had a transfer on death registration, then of course, upon death, it would transfer to the next owner. Leased vehicles are very, very unique because you kind of own the car, but not really. And the deceased for sure owes the money. And so if you have a leased vehicle, it's probably worth a discussion with us or an attorney because the estate is very likely to owe the money fully if the leaseor, right, so the car company, the dealership does not take the car back. So that kind of depends on the situation, but I would definitely, we should talk a little bit more about that one, offline.
So we have a few follow-up questions coming in. So first of all, Carrie's asking, can she upgrade from the $600 to $1,200 plan?
Absolutely. We offer upgrades. If you upgrade, you only pay the difference. So if you started with a $600 plan and then you said, whoa, this is way more than I bargained for, absolutely upgrade, and you would only charge you the $650 difference. Same with if you upgraded to the attorney plan.
Harry also asked, do I still have to list a vehicle as a debit if the vehicle has been taken back from the finance company?
Yeah, so essentially what happens when a foreclosure happens, or in this case, a forfeiture, no, that is no longer an asset. And typically the contract is fulfilled, which is to say the deceased no longer owes the money either. So that would not be an asset. That does happen obviously with real estate. And so just, beware, and that's well, somebody asked, is there a time limit? That's one of the biggest risks in probate. If you wait too long and there's debts on a house and a car, you could lose the asset. So yes, that is no longer an asset of the estate.
So another follow-up from Kajala is, so you sell the property. This is a follow-up related to selling the property. So you sell the property and their cash in the estate is in the state as a result of that. Does the estate have to pay all of the credit card debt regardless? Can an administrator choose to only pay a small amount to each credit card or medical bill? Does the court decide that for you?
Sure, great. So the question is, well, how do you deal with creditors? So mind you that creditors have to be dealt with, and that is a kind of open-ended question. So you are allowed to contact creditors and negotiate, right, to see if they will accept less. We have found when there's only a house in the estate, very little money, and somebody's going to stay in the house, creditors do discharge debts. So that depends. If there are assets in the estate, creditors may be less likely to discharge debt. So we do encourage you to have really good and clear communication with the creditors, and you are allowed to discharge debt. Again, it just kind of depends. So you really should communicate with the creditors. You mentioned something about medical bills. So there is an order of priority as to who gets paid. Something we didn't touch upon. So the order of priorities for payments out of the estate are the following. Funeral is always the #1 priority. So the funeral would be the first person to be paid anything out of the estate. Second priority is the administrative expenses. I'm a person with analogies. So I think of if the estate had a horse, right? You got to feed the horse, you got to clothe or brush the horse, anything to keep the horse alive, you have to do. Otherwise, the horse dies and there's no asset. So what would be that kind of expense would be, the attorney fees, the administrator expense. So the administrator executor can take a fee that comes second in line after the funeral. Anything that, requires payment to keep the asset alive. Think of like insurance payments on a house, anything that protects the assets. Then it's creditors, then it's taxes, IRS, state, local, real estate taxes, then it's creditors. The only creditor that can supersede all of these people would be a mortgage or some kind of asset that has a lien, because that's a contract prior to death, and a mortgage foreclosure. In fact, somebody just mentioned that somebody took the car, that will supersede anybody because that is a contract that was done prior to death.
Okay, I think 2 more questions. Gravette here asked, my mom has a timeshare in California and they are requesting proof of executor. I have the death certificate with my name, but they're the only one asking for executor of estate. Can I only show the death certificate? They're the only one asking for that. I believe corporate is either Nevada or Florida. I'm not sure. My only stall is with them.
Sure. Okay, so timeshares are tricky. So there are 2 types of timeshares. There is a timeshare that is treated like a stock, right? So think of like IBM stock, GE stock. That is what's called a personal asset and not necessarily located in one place. So if the timeshare is treated more like a stock, you probably don't need the deed transfer. You do need probate because you need to legally transfer the ownership. Again, you can't show up with a death certificate, just like I can't show up to your bank with a fake death certificate and say, give me all your money. You would need the order from the court. But depending on the title, it's how you would ultimately transfer. If it's a deed related timeshare, well, then the deed has to change. And again, the same thing, you still need probate. So only assets that transfer automatically without a court order bypass probate. It sounds like you've had those assets. It looks like this is one asset that you will need to do probate in. And mind you, many states have what's called small estate processes. And so if the estate is small enough, timeshares typically are not very valuable, you would qualify for the simpler probate process, which may not be the full probate, and it's usually faster.
And then Kajala had, so if the heir and not the administrator paid all the funeral expenses and EZ-Probate fees, is his expense paid second?
Great question. Yes, you would be a creditor. And so just like the funeral is first priority, that portion of your expenses would come first. And so what typically happens is once the estate is open, has access to money, you can immediately start paying expenses, reimbursements of things. Because obviously, like in my example, I was already out the funeral costs, already out some mortgage payments when I was the executor. And so, yes, you can instantly pay yourself back because those are administrative expenses.
And I think a perfect closing question is, or it's a comment, is from Debbie just saying, I want to thank you, Byron, for caring and having such a wonderful way of helping family through this stressful time.
Well, I appreciate that. Again, feel free to contact us on our website. You can schedule a free consultation. You can ask questions, and we are available throughout the day, typically through like 8 p.m. and then also on the weekends, 10 to 4 Eastern time.
And I think that's a wrap.
Oh yeah, disclaimer. Yes. Our legal team messaged me that please note that we are not a law firm. I am not an attorney. Anything that we said here today is not considered legal advice. If you do need legal advice, please consult a licensed attorney, or you can contact us and we can refer you to one. We are very thankful that you came, and I think again we'll put a link for anybody to contact us, as well as schedule a free consultation online. And I think we have everybody's email because of the registration. So we'll follow up with an email as well.
Thank you, everyone.